Whenever you're ready.
May it please the court, my name is Glover Wright from the Shelby County Public Defender's Office. It is my privilege to be here today representing Michael Cook. It is good to see Judge Campbell again in a new environment, and I do apologize for being the only thing standing between your honors and lunch. I would ask if I could reserve 5 minutes for rebuttal.
Thank you. Yep.
Your honors, I'd like to begin by running through just a short summation of the facts that are in the record here, and then I'd like to address 3 specific legal issues.
Well, before we get into any of that,
Yes.
let's talk about procedure. So let me, and when I say, rather than me just say, tell me where we are procedurally, let me tell you my understanding of where we are procedurally, and you can tell me if I'm wrong. Client is convicted to 2 counts. There's a sentencing hearing. Trial judge pronounced his sentence. There's 2 judgment forms that are prepared. They are filed with the clerk. At least one of them is signed. You and whoever, but someone goes and shows up at the court and says, hey, we're late on our motion for new trial. But before you do that, or about the time you do that, there's a notice of appeal filed that's already late as well because it's been 30 days since the judgments have been filed. We grant a delayed appeal or waive the timeliness of your notice of appeal, I guess is a better way to say that. Therefore, we have assumed jurisdiction of the case at that point. Sometime after that, trial judge says, you go back to the trial judge and the trial judge says, hey, we've noticed that you didn't sign judgment form number 2, which point in time, the trial judge signs judgment form number 2 and asserts jurisdiction over the case and allows for a motion for new trial. Is that all correct?
Yes, that is what the record shows. I would say I was not the attorney involved in
I'm just saying you because it's easier. It's easier for me just to say you or the defendant, so.
But I just want to be clear, I'm speaking from the record and not from any personal knowledge of what happened.
Procedurally, that's how it unfolded.
That is correct, Your Honor.
So my question then, if I am correct, the trial court had no jurisdiction to hear the motion for new trial because jurisdiction had been asserted by this court, and the only act that the trial court did is basically correct a clerical error because she went back and signed a judgment form that had already been filed with the clerk's office. So how do we have anything but plain error now?
So that's what I was hoping to wait for rebuttal to address because I knew the state would probably spend a lot of time on that.
Because it bears on how you address all the arguments going forward. It's either true, straight up normal appeal with a correct motion for new trial, or it's plain error. So to me, there's no point in discussing the meat of the issues until we know where we are.
And I do appreciate that, and so I will take Your Honor through what I think the arguments are in favor of the issues having been preserved, and the trial court having had jurisdiction to consider that late filed or arguably late filed motion for new trial. The first question is whether the court actually entered judgment on the date of the sentencing hearing. And as Your Honor has acknowledged, the trial court failed to sign one judgment order and used that failure as the reason for finding that it still had jurisdiction over the case and could consider a motion for a new trial filed within 30 days if that corrected what the court referred to as a corrected judgment order. And so the question is whether a court's failure to sign a judgment does in fact mean that judgment has not been executed and the trial court retains jurisdiction. Now, I would direct this court to State v. Richards. That is an unreported case, but it's 2023 Westlaw 6972550, page 8. For the
Is that in your brief?
It is, Your Honor.
Okay.
For the provision that an unsigned order, whether file stamped as this was or not, has no effect. In that case, the court disregarded an unsigned but file stamped order denying the suppression of evidence.
There was more to that than just the fact the order wasn't signed. You had the transcript was in direct conflict with what the unsigned order said. So there was a lot of ambiguity there about what exactly the court, what the ruling of the court was, because the court orally announced one thing, and then there was an order submitted dealing with probable cause being found, and the judge never signed it. So there's a little bit of difference there because you had a discrepancy within the record. The transcript said one thing, the order, unsigned order said something else. And there's no minute entry. There's no minute entry that was submitted here, was there? The minutes of the court for that particular day?
Oh, I'm sorry, I thought you said amended. There's no minute entry that's in the record.
But no minute entry, okay.
That's correct, Your Honor.
All right.
And in fact, Your Honor, I believe that is because, if I understand the record correctly, that there was no minute entry entered to be in the record with respect to that judgment. I think that was not done on the day of the judgment being entered. But I would have to double check that.
I would find that hard to believe that when it was file stamped on August 11, that it wouldn't have been put in the minutes and signed within the next day or two.
I don't want to state something that's incorrect, Your Honor, but I will double check, and if that is correct, I'll file something with the court to let Your Honor know. I do understand that there is a distinction between the situation and State v. Richards. However, I would just point the court to that case to suggest that there is some authority for an unsigned judgment or unsigned order having no effect. We also, in our brief, cited State v. Williams. That was a 1976 Tennessee Supreme Court case, 547 Southwest 2nd, that held a trial court's unsigned bill of exceptions. It had no effect. So again, I'm not saying this is a directly analogous situation, but there is some law that suggests that when a court does not sign an order, that order has no effect, and if that were the case here, the judgment would not have gone into effect, rendering the motion for new trial untimely. So that's how I would address the question of that order. With respect, Your Honor, to the question on whether the trial court had jurisdiction once notice of appeal or a motion to file a notice of appeal is filed with this court, Tennessee Rule of Appellate Procedure 4D suggests that a notice of appeal is premature when filed before the entry of judgment, and that a premature notice of appeal is treated as filed after the trial court's entry of judgment. And so the answer to that question depends on the answer to the first question.
Right.
And so I don't mean to suggest that the trial court would have jurisdiction in any other way, but if the court were to find that the judgment had not been signed and not been actually entered on the record, in that case, Rule 4 would allow this court to treat that notice as prematurely filed, meaning the trial court would still have had jurisdiction to consider the motion for a new trial when filed.
Yeah.
I did also want to address what Your Honor said regarding whether this was a clerical error. What the trial court found was that it had failed to sign one of the judgment orders, and that order bore no signature, it contained no sentence, and it left the question of merger unaddressed in terms of merging of the counts. And so rather than amend the judgment sheet, the trial court actually entered the sentence separately and distinctly in an order on November 18th of 2022. And what I would suggest that if the trial court had merely corrected a clerical error, it would have said so because trial courts do speak through their written orders. That's from State v. Albright, 2017 Westlaw 2179955. But the trial court's written order clarified its understanding of the record around the timeliness of the motion. I would also point, Your Honors, to Rule 24E of the Rules of Appellate Procedure, which describe the trial court's powers to supplement or correct the record. And when making such clarifications, that rule says the determination of the trial court is conclusive. So the trial court did determine that it had failed to enter judgment here. It did determine that because of that, the motion for new trial that was ultimately filed was timely, and it did have jurisdiction to actually consider the issues of that motion at a hearing on the motion.
Here's where I'm confused. I have count 1 and count 3, is that correct? I'm looking at the judgments.
Yes, Your Honor.
that you put in, that were in the record.
Yes,
Count one that was filed 8/11/22, that's the stamp filed, shows sentence imposed 8/11/22 and shows 25 years Department of Correction.
yes, Your Honor, that was the date of the sentencing hearing.
I understand that. And then you have, on the back page, Judge Skane signed the bottom of the first page. The second page, she signs it and dates it 12/12/2022. All right, now the other count three, is 8/11/2022. Shows 12 years as the sentence. Shows a jury verdict. And it shows date of entry 8/11/2022 on the second page. So what I'm confused with is, was the judgment altered? Or is there a judgment missing? Or, because both of them look to be, at least looked like both of them were signed, at least the front pages were signed. And both of them had sentences. So when you're saying that she didn't sign it and there was no sentence and didn't show merge or anything, are we missing a judgment?
And Your Honor, I can only talk about what I have in the record as
I
well.
understand that.
And so I think Your Honor has fairly laid out what I understand the record to be and what I understand to exist.
Okay.
And
But I
so,
thought you said earlier that she indicated, Judge Skane indicated that one of the judgments not only was not signed, there was no sentence on it, and it didn't say anything about merger. And then, so she then determined that she hadn't actually sentenced the defendant, and therefore, motion for new trial was still available to be heard by her. I just don't see any judgment that supports that. And I just want to make sure I haven't missed something where there's something that's not in the record.
I don't believe so. And Your Honor, count three is on that order. That does not note whether it was merged with count two.
Well, I understand, but that would be a clerical error. But because obviously she would have said so in the sentencing if it was merged or not. But you know, I'm looking at a file date, I'm looking at signatures, and I'm looking at sentences. So unless it was modified or unless there's a missing judgment, I'm not following.
And Your Honor, I think you fairly laid out, again, what is in the record. And I think that there is confusion over what happened on, for example, November 18th versus in December, as you've said. And what I would just say is that this goes to the question of, should Mr. Cook in this case be penalized when the record is so unclear about what judgment was entered when and how? And Your Honor, I would point the court to State v. Adams. That's a 2011 case from this court, 2011 Westlaw 5553485. And that case involved calculating a deadline for where the record showed conflicting evidence for when the trial court entered judgment. It can be distinguished, but it's a similar situation, I would argue. And in that case, the court said that any confusion over the issue should not inure to the detriment of the defendant.
Well, but the confusion is based on lack of record, but I think the transcript would say what happened on the date, the original date of sentence, which would have been, what, the November the 8th, or whatever date that is?
8/11?
Excuse me, August 11th. I'm sorry, not November. August 11th was the original date of sentencing from the Pierce line. So if the transcript indicates all this was done, I would think the transcript would control, wouldn't it?
I would say, Your Honor, that the written order would control, the written order that the trial court entered on November 18th of 2022, because as we said earlier, courts are presumed to speak through their written orders. Judge
Well, they speak to
Skane,
their minutes, which we don't have a copy of.
yes, Your Honor, but Judge Skane was the one who, again, entered an order finding that the court had previously not entered judgment on account, and used the trial court's discretion to find that the motion for a new trial was, in fact, timely filed. I would just note, originally, what happened in the trial court when counsel realized that a motion for a new trial had not been filed within 30 days of the sentencing hearing was that the council actually requested a hearing essentially on whether Mr. Cook should be given a new attorney. And
Well, I've looked at his affidavit that he filed with this court,
yes, Your Honor. And
spelling all that out.
And so the state at the trial court level is actually the party who asked the trial court if they would consider a hearing on what they then thought would be a late filed motion for a new trial,
Yeah,
which,
but as you know, the state, the defense, the judge can't create jurisdiction.
I understand that, Your Honor, and I see that I'm at the end of my time.
Sorry.
That's why I
But,
hope to.
the problem is, this issue determines the entire review of the entire case. And to your point, I want to address very quickly, and we'll make sure you get your rebuttal time, but is when you talk about confusion shouldn't err to the detriment of the defendant, I don't know that I'm confused by looking at those documents as to what happened. What happened was all the judgments were entered in August. Nothing happened, and so the trial court, to use Judge Campbell's term, created jurisdiction in December. So, I mean, to me, I think it's a plain error issue, but we'll obviously review it. But we'll give you time to at least try to address some of those on your rebuttal.
I appreciate that, Your Honor. That's why I hope to save it, but I do take the court's point that it governs what happens. So thank you, Your Honors, very much.
Thank you. General, I guess you can't figure out what we want to talk about, can you?
I'll take a stab at it. May it please the court, Catherine Redding on behalf of the state. The defendant waived plenary review by failing to file a timely motion for new trial. And I think the record is actually fairly clear on this point. It shows that in March 2022, the defendant was convicted on 3 counts and acquitted on 1. Count 1 was an aggravated rape. Count 2 and 3 were alternative counts of aggravated kidnapping, and count 4 was theft. On August 11th, 2022, and this is borne out in the sentencing transcript, the trial court held a sentencing hearing. It merged count 2 into count 3, sentenced the defendant to 25 years for aggravated rape and 12 years for aggravated kidnapping. Then the state prepared judgments of conviction for all 4. The court signed the judgments for counts 1, 3, and 4. So the aggravated rape, the lead aggravated kidnapping, and then the acquitted theft case, but failed to sign the judgment of conviction for count 2, which was the merged count that had been merged into count 3. So we have 4 judgments of conviction, 3 signed. Those are the acquittal, and then the 2 lead cases that control the sentence. The trial court clerk stamp filed all 4 judgments the same day. The defendant had 30 days from August 11th, 2022 to file his motion for a new trial. He did not file that. As a result, his judgments became final on September 12th, 2022, and the defendant waived plenary review of any appellate issues other than sufficiency and sentencing, and he has not raised either of those issues on appeal. The trial court's finding that it retained jurisdiction is a nullity, and therefore the defendant's motion for a new trial that he filed subsequent is also a nullity. The defendant's judgments became final in September, and on October 31st, he filed a motion in this court to late file a notice of appeal. On November 4th, this court granted that motion to late file and filed the notice of appeal. He had presented one as a conditional notice of appeal. November 4th, this court assumes jurisdiction. The things that happen afterwards, the trial court finding, oh, look, it appears I haven't signed count 2, that is not, it created jurisdiction where it did not have the ability to do so. So there is no timely motion for new trial. There is no plenary review of any of the issues the defendant has raised in this court for appellate review. And
Okay.
I don't really have anything else to say on this point.
And I know he didn't get into them, but he will on rebuttal. So while not normally would I allow you to argue things that he did not argue, I'm going to allow you to do so. Mainly because I'd like to discuss the plain error on the using the voice identification from a moment hearing. How is that allowed? How do we force a defendant to testify who wasn't going to testify, and then use that testimony to make an identification?
Sure. So, as we've established, the defendant is raising this for plain error review. He has to show all 5 of the plain error requirements before he's entitled to plain error relief, and he just is not able to do that here. First, the defendant cannot establish a breach of a clear and unequivocal rule of law, which is what is required for plain error. There is no case law on this point. This is an issue of first impression, which he acknowledges in his brief. So when you have an issue of first impression, you cannot then say that there is a breach of a clear and unequivocal rule of law, because such a law does not exist. It's not been considered. The defendant also cannot show that one of his substantial rights was affected. And this goes to, he's claiming that by admitting the voice identification, the trial court was penalizing him by asserting his right not to testify, and it interfered with his right to cross-examine the victim. But the case law on on a defendant's voice is more of a physical characteristic, and that's why the admission of voice templars is permitted, because a defendant is not being compelled to speak at trial so that the jury can determine his guilt based on what he's saying. He's being compelled to speak so that the witness can hear his voice and make an identification. So it's a bit strange, because he is compelled to say words in court under Momon, and he has to do that personally, but it is really a matter of what is the voice. And the voice is a physical characteristic, and that tracks with the case law that comes from the U.S. Supreme Court that allows this. So if you can say that the defendant could have been compelled to speak at trial, to say the words that the victim says the perpetrator said, if that is allowed, then certainly having a defendant be required to say at his trial whether he is going to invoke his right to testify, or pursue his right to testify, or whether he's going to invoke his right to remain silent, that it cannot be that it adversely affected a substantial right. And I'll direct this court to the record. Also, if you look at the words that the defendant is saying, said at his Momon hearing, and it's fairly typical of a Momon hearing, but it's yes, yes, yeah, I don't know. It's very, very limited. And finally, the defendant can't show, there's 3 out of 5 prongs that he cannot, requirements that he cannot establish, and he cannot show that there's a need to do substantial justice. The victim's identification did not result from an unduly suggestive identification procedure. It occurred in court. It did not involve state action. This is something that is required by the case law of the Tennessee Supreme Court. The identification was reliable because she had an opportunity to hear the perpetrator's voice during the commission of the crime. She paid remarkable attention to what was occurring during the offense, and knew that she wouldn't be able to see the defendant. She couldn't see the defendant's face, or the perpetrator's face, so she needed to pay attention to what was happening. And she was able to. She testified that she never saw his face. She would not be able to identify the perpetrator by sight, but she did have ample opportunity to observe the defendant at trial, and only recognized him after she heard his voice. And indeed, her testimony identifying the defendant as the perpetrator did not call any attention to the fact that the defendant had had elected not to testify. It was merely, I heard his voice and I immediately was taken back to the circumstances of the offense. And indeed, the defendant had the ability to cross-examine the victim about her identification and brought out several points about the voice, including her testimony that she he elicited testimony that she had told law enforcement in the immediate aftermath of the rape that the perpetrator had tried to disguise his voice. And so brought out testimony, well, if he was trying to disguise his voice during the rape, then how would the defendant, who was not trying to disguise his voice during the Momon testimony, how can you make an identification if that is true? And he made extensive arguments about identification during closing arguments. So because the defendant is required to establish all 5 of the plain error requirements and cannot establish all 5, he is not entitled to plain error relief on this particular claim. If there are any more that the court would like to discuss.
I was going to say, I'll let you, because I'm going to let him have free reign on rebuttal, which would not normally happen. So if there are any of the other issues you'd like to address, feel free to do so.
I've not been in this position before, so I cannot
I know.
say that I hope to anticipate what my opposing counsel is going to argue. Could I request 2 minutes to respond to him? Sir, rebuttal?
We'll see what he has to say.
Okay.
How about that?
I suppose I'll just ask this court to affirm the judgments of the trial court, rely on my brief for the remaining issues, and listen for what my opposing
Your
counsel has
brief's
to say.
well written, so you're probably
Thank
okay,
you.
but we'll see what he has to say.
Thank you very much, Your Honor.
I've also not been in this position before, so I appreciate the court's indulgence here. I would like just very briefly to run through the facts that I think are important for the court to consider in just a minute and a half. This is a case where a ski-masked man raped CS while, according to her testimony, he disguised his voice. 12 hours later, police across town used admittedly dirty gloves after touching dozens of items to collect a condom found inside a stolen Camaro. There are a number of exhibits I'd ask your honors to consider, in particular Exhibit 24, which is the body camera footage that was shown to the jury, Exhibit 25-3, which is a picture of those dirty gloves, and Exhibit 38, which is a picture of the visibly dirty condom in this case. That condom was visibly dirty prior to testing. Investigators sent that condom for testing and packaging that degrades DNA. TBI issued a report on the DNA that they had to correct twice before trial. Mr. Cook filed a pretrial motion to dismiss after his expert concluded that the police had contaminated that condom, and the court found in a written order that the condom was in fact contaminated and that it was contaminated due to police negligence. The court reserved a ruling on a remedy until trial. Mr. Cook moved pre-trial to keep unreliable and suggestive identifications out of his trial. Again, the court reserved a ruling on that. At trial, the experts disagreed in some respects, but agreed it was possible that there were 3 people's DNA on the condom, Mr. Cook, CS, and perhaps an unknown third person. In the words of the trial court, the defense did, quote, very well before CS identified Mr. Cook's voice from a few words of his Momon testimony. The trial court then denied motions for remedies under Ferguson for failure to preserve evidence, for jury instructions that included identification, and for a mistrial after the identification subsequent to that Momon hearing. Now, the state argued in its initial closing that CS would not forget her attacker's voice, that she should not wait for a conviction, and that defense counsel wanted to confuse the jury. In rebuttal, the state then argued the victim was credible and that Mr. Cook's right to silence prevented a pretrial voice identification. As your honors have well covered, counsel did not file a motion for new trial within 30 days of the sentencing hearing, which is what leads us to today. I think that there are 3 issues of the issues that are raised in the brief that I would just ask the court to seriously consider as it weighs what to do here. The first is that the clear right to a fair trial required a remedy of some sort when police breached the duty to preserve the DNA evidence.
So I'm going to ask you about that. There's a difference between a duty to preserve and arguing that evidence is contaminated. I mean, to me, the duty to preserve by the state is they have to keep the evidence. They can't let it get lost or destroyed. The fact that a police officer may have contaminated evidence during collection is not lost or destroyed evidence. It's a contamination argument. So it's not a Ferguson case. It is, hey, you get to stand up and argue and cross-examine the police officer about his shoddy work, and then make that argument to the jury, and then maybe even put on your own expert that cross-contamination and this, that, and the other, that's your remedy, because the evidence isn't lost or destroyed, it's just potentially contaminated, correct?
Well, Your Honor, what has been destroyed is the possibility of the defendant using it as purely exculpatory evidence. It is clear from the record that Mr. Cook's DNA was found on the condom. It is not clear where that DNA came from. It is not clear how that DNA got there.
But again, to me, that's not what Ferguson is contemplating when it talks about destroyed evidence or lost evidence. It's talking about it doesn't exist, it's gone. This is a contamination argument. I mean, you and I both seen it numerous times. You get the crime scene investigator up there, and defense counsel hammers away about, well, you touched this post, and then you went over to this part of the bedroom, and you did this, and you never changed your slippers, or you never changed your gloves. That's a contamination issue. It's not a Ferguson issue.
Your Honor, I would say that Ferguson addresses this when it talks about I believe there's a case where police taped over a part of a video, that they had a duty to preserve that video. So I would argue that Ferguson does apply and suggest the court should at least apply a jury instruction. I know I'm out of time. I did want to respond to your question about the identification, or at least what the state said with regard to the moment identification. The state argued that there was no breach of a clear and unequivocal rule of law. We would argue, as we argued in the brief, that in fact there was a clear breach of the defendant's right to remain silent under not just the Fifth Amendment, but Article 1, Section 9 of the Tennessee Constitution. And also there was a breach of the clear and unequivocal right that a defendant's exercise of its rights cannot be used against him after assurances that doing so will carry no penalty. And for that, we cited the United States Supreme Court case of Doyle v. Ohio. With that, I do understand my time is expired, so thank you very much for hearing me.
Thank you. I assume you have no rebuttal? I do not. All right. With that, are we finished for the morning, Madam Clerk?